If you're reading this page, it may be because you've just been arrested, you've been questioned, you've been detained at the police station, and you've just been released. And you're now looking around, wondering what the heck is going on, what can be done? Well, there's lots that can be done pre-charge. If you're at the stage where, following an arrest, you're just waiting for a charging decision, don't just sit around and wait. If you've had a duty solicitor at the police station, that solicitor may have said to you, well, there's nothing really that can be done. You just need to wait for a charging decision. That charging decision may take 12 months, may take 2 years, particularly if there's any downloads that need to be completed, such as phone downloads, computer downloads, and so on. So don't just sit around and wait. There's lots that can be done. It's what's called pre-charge engagement. And that's where we, as solicitors, if I'm acting for you, for example, then I'm allowed to engage with the police, with the investigating officer, perhaps with social services, perhaps with your employer, if the employer's involved, certainly with the authorities to find out what's going on with your case. What is the evidence? Why have you been arrested? What can be done? And when the police have completed their investigation, they will then refer that matter through to the Crown Prosecution Service. And the CPS have reviewing lawyers who advise the police as to what is the appropriate charge. Well, if you do nothing at all, if you just sit around and wait, that reviewing lawyer has not heard your side of the story. He knows nothing about you. All that person is hearing, or the danger is all that person is hearing, is what the police are telling them. And the police are, in my view, pro-prosecution. They're looking at things, the evidence against you. What have you done wrong? So they'll hear the complaints against you. What we have to do to redress that balance is to take the necessary steps to show why you have not committed the offence, but also not just to deny the offence, not just to put a defence forward, but we also need to show why the evidence does not pass the prosecution charging standard. By law, nobody should be prosecuted unless the CPS reviewing lawyer determines that it has reached the code for Crown prosecutors, that it's reached a level that deserves prosecution. And there's a two-part test to that. One is it's got to be in the public interest to prosecute you, but also there has to be a realistic prospect of a conviction. And so what we can do early on in a case, not waiting for a charging decision, it might be a year, but straight away, action now, is that we can start looking into the background of this, your story, your version of events. What is the evidence? What's the complainant saying? What's wrong with that evidence? What's wrong with what affects the credibility of the complainant? And also looking at your credibility. And we have to then be able to present that to the Crown Prosecution Service in due course, and to show why it doesn't reach the prosecution charging standard, that there is no realistic prospect to the conviction, or it's not in the public interest to prosecute. But they're issues that need looking at early on. If you don't have a solicitor working on those things for you, then who else is doing it? Because the police are not there to present your defence arguments. The police are there looking into the complaint that's been made against you. If anything, they're more pro-prosecution. They're trying to find reasons why you should be prosecuted. What we need to do as your solicitors, and we're the only people on your side, if you think about it from a legal point of view, we have to look at things as to what is your defence? But also, what can we do to try and stop you being charged in the first place? They're issues that need to be looked at early. So be proactive, take steps, contact us now.